Good morning. May it please the court. Mary Lou Cuellar-Stilo and Mark Tinker seated at the council table on behalf of Critical Intervention Services. I would like to reserve 5 minutes for rebuttal. This court should reverse the trial court order granting summary judgment in favor of TICO and against Critical Intervention because the contract between Critical Intervention and TICO, including the amendments and the work orders, was ambiguous, and Critical Intervention therefore had no obligation to indemnify TICO for its own negligence. And because the trial court erred in excluding or ignoring key provisions of the contract in order to reach its decision in granting summary judgment to TICO.
Can we start with jurisdiction? We're just going to ask a question on jurisdiction.
Absolutely.
The prayer for relief in TICO's complaint says they demand judgment for indemnification, and then they demand attorney's fees and having to defend against Mr. Trimble's claim, from which I could easily infer that TICO has resigned itself to the fact that even though the indemnification agreement in their interpretation requires critical defend, they're not going to get a defense. So what it sounds to me is that TICO was not even seeking in its complaint a defense. So that being said, isn't the only thing at issue the indemnification, and isn't that interdependent on whether ultimately there is liability in the ongoing litigation and the tort claim? And doesn't that lead to the conclusion that this is a non-final order that's not that it's not appealable?
Well, I disagree with that interpretation, and I'll tell you why. I believe that in this particular case, although the trial court never really ruled on that issue of the duty to defend, by making its ruling to indemnify, the court seemingly decided there was a duty to defend, but as you said, that wasn't clearly done. But in this particular case, I believe that the two issues are not dependent. I think that the issue we're dealing with today is a separate and distinct issue. And I believe that this at least issue that we're dealing with can be determined to be a non-final, a final.
Partial final judgment.
Partial final, thank you.
That is not a defendant.
Pardon?
A partial final judgment that is not in
Exactly.
defending claims such that it can be.
Well, let me ask this. The judicial effort is not over. Judicial labor is not over because there needs to be a finding of liability and an award of damages before you can have to pay it down. That has not happened.
But in this
order, excuse me, one second.
I'm sorry.
This order does not order you to pay any money at all at this time, nor does it require you to hire or retain counsel to defend TICO at all. It simply says, if there is a verdict against TICO of liability and award of damages, you'll have to defend. So how is this appealable? How is this appealable? I can't find an appellate rule that applies. This isn't an injunction. And our decision in Southeast Mechanical makes reference to what would be appealable if it was a mandatory injunction requiring the petitioner to provide legal representation in more instances. Doesn't do that here, or it enters a final money judgment. That has not happened.
If I may, at this point, I believe that the order is appealable as a partial final judgment because it is solely about the duty to indemnify, and it's distinct from Trimble's claim about
Does
damages.
your client have to do anything right now at all for TICO? Right now, as you stand here? No. No, they haven't been compelled to do anything by court. Right?
I do believe that it could be a separate and distinct lawsuit alone, the duty to indemnify. So it could be separate as to just that issue because it doesn't rely on the damages and it stands alone. Is there a duty for critical intervention to indemnify TICO? And I think that that's an issue that could be addressed in and of itself.
Did Southeast Mechanical rely on its conclusion? I think it distinguished Canal, is that right? In Canal, there was an actual separate action filed, if I'm correct, right? So was it crucial to this court's decision in Southeast Mechanical that the separate action was not filed and therefore it was not an appealable order because there was underlying the tort liability was yet to be determined, and therefore, since it was merely about indemnification and not to defend, that it was not an appealable order? Was that a correct or incorrect reading?
I'm not quite sure. I would have to look
Neither
at
am I, but I wish you could answer the question. No, but I think that's important, and maybe Kelly's could speak to that. You know, what was important to this court that led the court to believe there was not jurisdiction is the fact that it was not filed. You didn't file a separate. I mean, TICO didn't file a separate action.
No,
So under Southeast Mechanical, do we not have jurisdiction? Don't we not have jurisdiction?
I would have to look at the case and answer that question, or I could.
That's what you move on. I mean,
Okay.
neither of us know, so we'll set that on the back burner.
Okay, thank you. So at this point, the contract involves several different amendments to the agreement, the original agreement with the party. And in this case, we are indicating that there is ambiguity to the contract, and that's the primary reason that we are asking for reversal of the.
Let me ask you this, in the 3 iterations of the agreement, there is language in each iteration that says you're going to indemnify TICO from its own negligence. In every iteration.
You're correct, Your Honor. However, there are different iterations and they don't work in harmony with each other. For example, in the 2008 agreement, critical intervention was required to completely indemnify TICO and critical intervention was referred to as an independent contractor in that particular agreement. And it was required to indemnify TICO for sole liability, concurrent liability, and it was very specific. In the 2009 agreement, there was an exception to the indemnification that if there was anyone who was injured or was a death resulted or damages, or injury or even property damage, if critical intervention was indemnified from providing indemnity, there was an exception to that. And so they would have to, unless it was a critical intervention employee, if the damage or injury was caused by an action that was either a criminal action or an unauthorized action.
But that was part of an amendment that gave critical intervention sort of the authority to issue trespass warnings, that kind of thing.
It gave them agency. It created, they made critical intervention and its employees agents for the purposes
of executing that sort of notice.
Well, and I think that's an important distinction, Your Honor, because that work order that applied to that indicated that that was for purposes, they were agents for purpose of swearing out affidavits, for purposes of issuing trespass warnings, for purposes of providing, in essence, security function, which was their role anyway.
Well, if I make them an agent for that purpose, so what I don't understand in briefs, I'm having trouble understanding the critical intervention in TICO as a result of that. First Amendment are one and the same. That just strikes me as implausible.
Well, the language specifically provides that it was, TICO was in making critical intervention, and remember their sole role is for protection from terrorist threats or they're basically security.
So you're saying that there is no indemnification or duty to defend at all because an agent, because one fictional entity or can't indemnify itself?
I'm not saying that, Your Honor.
So then let's break up what the amendment making one entity the agent of the other eliminated and what it did not eliminate.
Okay, so basically, critical intervention and their employees were designated as agents for the purpose of issuing trespass warnings, swearing out complaints, and other protective functions. However, what happened with that is that critical intervention was responsible for indemnifying TICO if anyone who was injured was an employee of critical intervention. And then in that case, they were required, critical intervention was required to indemnify TICO for those actions, any actions of TICO's general negligence. So as opposed to the 2008 agreement, the 2009 agreement was different because it not only made critical intervention an agent, but it also indicated that at this point, as opposed to the sole negligence or concurrent negligence, they were responsible for indemnifying TICO
So
of general
the
negligence.
provision that was added by virtue of the other provision making one entity and agent together was ineffectual. So in the very amendment, correct me if I'm wrong, added both the agency provision and then in addition to the indemnification provision that broke out separately actions involving injury to Critical's employees. So that was just a dead letter on arrival because
Well, you mean when you say dead letter?
I'm just saying you're just saying, well, it just had no effect. It's like, well, good try, everybody, but we just killed our own new indemnification provision.
By making them their agents? Well, I believe that it raises an issue of ambiguity because.
What's the other way to interpret the new provision saying providing indemnification obligations for claims arising from injury to Critical's employees? What's the other interpretation?
Well, exactly, that the agency issue.
No, what is it?
The agency issue makes critical intervention an agent of TICO, and that at that point, how, if they're an agent and if the indemnity provision requires that critical intervention indemnify TICO, including its employees, its agents, its its contractors, or it's basically the people that work for TICO are being indemnified. So critical intervention becomes one of those people, one of those entities, because they're required to indemnify agents of TICO, and critical intervention itself is designated an agent of TICO in the Second Amendment.
You're at your 15 minutes, so use your time as you wish. I just want to hit that.
So I will, at this point, reserve and for rebuttal. Thank you.
We'll give you 5 minutes on the part. Thank you.
Thank you.
Good morning, Your Honors. Elbert Martin for Tampa Electric Company. May it please the court. So we're here today. Lower court granted summary judgment requiring CIS to indemnify and hold harmless Tampa Electric Company.
I'm assuming from your, the preferably from your complaint and from your arguments on appeal to current jurisdiction, that you read the trial court's order as not making an adjudication of the requirement to defend, or at least not imposing an immediate obligation to defend, which would eliminate from consideration this order as being one in nature of injunction.
That's correct, Your
But does it
Honor.
also bear then upon the interdependence? In other words, if this order could be read to be an adjudication of the present obligation to defend, then is at least that portion of the order appealable, because that's not interdependent on the pending tort claims. It's already done. You're supposed to defend, start defending.
Yeah, we would agree with that, Your Honor. So the CIS moved under Rule 9.110K, the partial final judgment rule. Based on that notice of appeal, we filed our motion to dismiss based on Southeast Mechanical because we felt like it was a potentially binding court on this panel. We wanted to raise the question of jurisdiction for your analysis. However, in CIS's response, they mentioned a new rule, 9.130A3B, which is they're saying, well, the duty to defend is in the nature of an injunction. So we obviously didn't address that in our motion to dismiss. But at this point, we would take no adverse position to the court having jurisdiction if they view the order as having a duty to defend that is in the nature of an injunction.
So you would be just fine if we decided we had jurisdiction and we affirmed the trial court's order adjudicating an present obligation to defend as well, so then.
Yes, Your
Not
Honor.
surprising. But let's go back to jurisdiction because we need to know how we resolve this case. Either we have jurisdiction and we had a reverse or affirm, or we dismiss. So, and you opposed jurisdiction.
Correct. Based on the partial final judgment rule, we don't believe that this is a partial final judgment under Rule 9.110K
Because it's interdependent.
because it's interdependent and as
So
Judge
the appellants have said, made a plausible argument that there is no interdependence. I mean, it's intertwined, but it's not dependent. In other words, regardless of whether there is or is not ultimate liability, the judgment of the trial court stands. This judgment of the trial court is implicitly contingent on there being liability for which indemnification will be required. But what the court adjudicated was whether that obligation, whether this lawsuit gives rise to a duty to indemnify against any liability that might ultimately be decided. So why is it interdependent? Why is it dependent on pending litigation?
Well, because we viewed Southeast Mechanical as saying it was. So when we read that second DCA case, again, we wanted to raise it to the court's attention. We questioned whether the jurisdiction is here or not based on that order, which seemed to be potentially binding, right on point. So that's why we.
So what do you think of Southeast Mechanical? My questions earlier, I may have botched the whole thing, so you can correct me, but what was the crucial aspect of the posture of that case that led to that panel distinguishing Canal as a case in which there was jurisdiction, whereas here in Southeast Mechanical there wasn't? Was it the fact that in Canal there was a separate action for implication, or is the distinction that in one of the two cases the duty to defend was at issue, but not the indemnification?
Yes, so I think there's two issues. I don't think the fact that it was a separate cause of action, I don't know if it was or not, I don't think that matters. I think it was whether the order has the requisite finality language. and whether there's an order that requires the defendant to, or the party to do something in the nature of an injunction. So in Southeast Mechanical, the court said, we don't have that, right? We don't have, we're just saying you owe indemnity, but we're not requiring you, as Judge Sleet pointed out, to actually do anything. And so I think that would be the key for this court's jurisdiction, is whether the trial court's order requires CIS to actually obligate them to come in, take over the defense and do something now versus waiting till the end of the case to pay for the indemnity that's determined.
Well, did you ask the trial court to enter an order immediately ordering critical intervention to obtain counsel and begin the defense and reimburse TICO for any legal expenses already incurred?
We have not.
And that's not what the order says, correct?
Correct. The order reserves jurisdiction to determine attorney's fees for what we've already spent.
So it goes back to my question. Does critical and intervention services have to do anything today at all?
Not by order.
Okay, so when is their duty triggered? When there's a finding of liability and award of damages?
Correct. Or if we moved under the trial court to ask them to defend us presently.
Haven't done that yet, have you?
Correct.
Regarding the amendment, so my understanding of your understanding of the amendment is that the negligence, the reiteration of Critical's obligation to indemnify for negligence, for TICO's negligent acts, is an exception to the exception, which is for unauthorized illegal or criminal act. In other words, you don't find this to be mutually exclusive. Your argument is that it could be an unauthorized illegal or criminal act and also TICO's negligence.
Correct, Your Honor. So if a CIS employee is injured by the negligence of Tampa Electric Company, then CIS owes indemnity to Tampa Electric.
So even if it was an unauthorized illegal or criminal act performed by TICO,
Correct.
if it is also negligent,
If it's a CIS
an
employee.
indemnification is required.
Yes, Your Honor.
Which we have here.
Correct.
So those are not mutually exclusive.
That's correct, Your Honor. And to go to a point that Judge LaRose made, this indemnity provision in the amendment can stand itself. So even if our original agreement, section 12, that indemnity provision did not exist, this amendment, the indemnity provision alone, would grant Tampa Electric the right to seek indemnity against CIS for CIS's own negligence. I know CIS's counsel mentioned the difference between negligence for sole, contributory, and concurrent negligence. One of the cases we cite in our brief is John W. Eshelman and Sons versus Seaboard Coastline. It's a second DCA 1983 case, 431 Southern 2nd 345. And in that, the language said, the language of the indemnity said that the lessor gets indemnity from any injury, death, loss, or damage resulting from the negligence of lessor. And the plaintiff who did not want to provide the indemnity argued that, well, it doesn't say sole negligence, therefore we don't have to provide you indemnity. And the second DCA says, we disagree. The common sense reading this provision leaves no doubt that Eshelman would be obligated to indemnify Seaboard for damages regardless of the extent to which Seaboard was negligent. So the fact that it says sole negligence versus just negligence has no bearing on the indemnity that CIS owes to Tampa Electric. And going back to kind of our arguments for why we believe this is clear and unequivocal languages, we have the original agreement in 2008, section 12, which says that CIS owes indemnity to Tampa Electric for Tampa Electric sole, contributory, concurrent negligence. We have a 2009 amendment, which is the second amendment to the contract, that doesn't alter that intent that CIS owes indemnity to Tampa Electric for Tampa Electric's negligence, but actually restates that intent. And then a 2013 amendment that restates the intent that both section 12 apply and that the amendment doesn't alter the intent of the parties, that CIS would owe indemnity to Tampa Electric for Tampa Electric's negligence.
Confirm for me if you would, there's nothing in the record that explains what prompted the 2013.
That's correct, Your Honor. There's no record evidence of why they filed the 2013 amendment.
One can only surmise that there was some point of confusion between the parties.
Or it was to avoid situations like this where someone's saying we don't owe you indemnity. We think that agreement was
But there is nothing that explains how. This
correct, Your Honor.
All right, that's what I thought.
So when looking at the arguments that CIS has provided to this council on the merits, they make 3 arguments, but 2 of those have been waived because they were never raised to the trial court below: their agency argument and their duty to defend argument. The only argument that's before this court that hasn't been waived is their illegal or unauthorized act argument. And in that argument, they look at the 2009 amendment and they say, well, it creates this exception to Section 12 indemnity for illegal or unauthorized acts by third parties. And the purpose was to avoid CIS indemnifying Tampa Electric if someone were to come into Big Bend, which is where this accident happened, commit a terrorist attack, commit some sort of crime on the property, and then CIS would not be obligated to owe Tampa Electric liability to it, except to the extent that it's a CIS employee who was injured. Now, CIS reads the first part of that hold harmless provision and says, well, we don't owe you if there's an illegal, unauthorized, or criminal act, but they fail to read the final clause, which says, provided, however, that CIS will continue to owe indemnity to Tampa Electric if the CIS is the one injured by the negligence of Tampa Electric Company. And so, as we stated earlier, that this provision alone would provide the clear and unequivocal language that would be necessary under University Plaza to provide, to require CIS to indemnify Tampa Electric for its own negligence. Now, the agency argument is waived. They never raised it. They had 5 opportunities in response to Tampa Electric's summary judgment and their own summary judgment, CIS's own summary judgment. We had 2 oral arguments, one for each summary judgment, and then in the CIS's motion for reconsideration, this agency argument was never raised. It's therefore waived. The fact that they said the contract was ambiguous for reason X below, for the First Amendment as opposed to the Second Amendment, and now they're arguing, well, the Second Amendment actually creates the ambiguity. The Florida Supreme Court in the Sanchez 2019 opinion says that a party may not rely on one line of argument in the trial court and then pursue a different line of argument in the appellate court. That's exactly what CIS is trying to do here. Therefore, they've waived the argument. I also think it reveals that it's not a very strong argument if it's the 6th time that they're trying to find an ambiguity, and it's the first time they can bring
Am I
it.
correct that the amendment that added the whole the exception to indemnification for criminal acts, et cetera, was the same amendment that included the agency?
That's correct. There's the 2009 amendment, which is the Second Amendment to
So
the
it's the same
contract.
one, so they can answer as the appellant, but by virtue of the agency amendment, it rendered the amendment to the indemnification, or at least effectively, and then it rendered it effectual.
That's,
Is there a way to carve out some effect that it could still have, even if we buy the agency argument?
well, I don't think the agency argument makes much sense because agents indemnify principals all the time.
I was just asking a separate question about whether could we still give effect to the amendment to the indemnification provision if we buy the argument that the
I don't-
agency amendment had some effect on it?
I don't think so. If you look at CIS's argument, they're saying that because CIS was appointed for this discrete duties as an agent, that it renders our entire indemnity meaningless. And I think that's what exactly this court and more, the second DCA 2005 says the court's not supposed to do, right? You're not supposed to interpret a contract in such a way as to render provisions meaningless when there's a reasonable interpretation that does not do so. But that's what CIS is arguing. They're arguing, well, because you defined CIS as an agent for these 2 discrete purposes, to issue warnings, to provide protection functions, that means your section 12 and indemnity is completely gone now, right? We're so confused over it, you have no section 12 indemnity. But what University Plaza instructs the court, we got to look at the party's intent, right? When you construe indemnity, what was the party's intent? And reading this amendment, there was no intent for the parties to give up Tampa Electric's right to seek indemnity from CIS for Tampa Electric's own negligence. Because as we've already talked about, the very last sentence or clause in this amendment says, provided, however, CIS shall still indemnify Tampa Electric if CIS employee is injured by the negligence of Tampa Electric. So the amendment itself restates the intent of the parties that Tampa Electric should get indemnity from CIS for Tampa Electric's own negligence. And Amendment 3, although you're right, Judge LaRose, we're not sure why it was put in there. It says for the avoidance of doubt, the Second, the 2009 amendment is not intended to replace or get rid of section 12, but it's intended as an additional paragraph. So again, this is a restatement of the party's intent that CIS.
What doctrine could there have been? Like, what would have been lost if it was replaced? You just said, you actually already answered the question. You said that this could stand alone and provide the same thing. So that's part of the mystery. Is
Well,
that
if
what
for our
doctrine
background.
could there have been? Given that your position is that even if the original indemnification provision, paragraph 12, where it was gone, it would be the same result.
Well, for non-CIS employees. So the idea
that's
is,
okay.
the idea is the exception to the section 12 indemnity was for these illegal
That's right.
criminal acts. And so losing section 12 would for anyone who's not a CIS employee would lose that indemnity. And I'll just go into the final argument. It's about the duty to defend, which as Judge Sleet has pointed out, we're not sure if the trial judge has even issued anything on the duty to defend, but it was raised, it wasn't raised below. And CIS's argument is that Mr. Trimble's injuries do not arise out of or in connection with his work. He was injured while he was working, but they seem to say he has to be injured by his work. We have cited a Fifth Circuit case from former Fifth Circuit from 1963, analyzing Florida law that it's almost the same fact pattern. It's electrical conduit, contractor at a chemical plant, the negligence of the chemical plant employees release phosphorus, the electrical conduit worker while doing their electrical work were exposed to the phosphorus. They were hurt. The parties argued about, well, was that injury in connection with their contract to work at the electrical work or the work they were doing? And the court said yes, because that in connection with is incredibly broad. And the Hagen Florida 5th DCA case says that arise out of is more than just, it's more than just caused by, it means in any, it means broader than caused by, it means incident to or having a connection with. And so pending jurisdiction, we would ask this court to affirm the holding of the trial court because it's a clear and unequivocal indemnity obligation that CIS owes to Tampa Electric Company. And absent any questions from the panel, I'll sue this.
Thank you very much.
Thank you, Your Honor.
Council, 5 minutes for the vote.
So in response to Judge Atkinson's question about Southeast Mechanical, that case indicated that a third-party declaratory judgment is appealable as a partial final judgment resolving issues presented in a third-party action. In a separate, does say a separate third-party action. So, but in addition, the third-party complaint alleges critical intervention.
The Southeast Mechanical said that they dismissed the lack of jurisdiction, my friend.
Yes,
You're saying that by implication.
I'm sorry. I'm saying that one of the indications, the findings in that case was that a third-party declaratory judgment is appealable as a partial final judgment resolving issues presented in a separate third-party action.
Didn't happen there. Did that happen here?
It wasn't a separate third-party action. It was
Did we have
a partial, it was a separate issue, but it was not a separate action. But my argument was that it could be considered separate and distinct because of the issues. But in addition, the third-party complaint alleges critical intervention has refused to acknowledge its indemnity obligation, and that the judgment for indemnity, it's on the record, page 29 to 30, and it demands judgment for indemnification. And the court's order enforces a declaratory judgment regarding indemnity obligations. And it's on page 360 of the record. And the order's only reservation of jurisdiction in this case is to award TICO attorney fees and costs. So that's another basis for why it could be considered a partial final
On
order.
the interdependence issue, what case or cases support that? The issue of indemnification is not dependent on the underlying. International such as this, or some of the, or described in South Campbell, where the third party, usually the party's not gonna sue another party to, declare or for breach of contract or indemnification if there's not some sort of ongoing threat of liability to which indemnification is required. So what cases do you have that suggest that it is not interdependent on the ongoing tort liability that would give rise to the liability to which indemnification is required? Maybe none, I don't know.
Right, right.
Maybe.
At this moment, I don't have one to give you. But the only other thing I was going to indicate is that this court may consider a declaration as a partial final judgment, not interdependent on the outcome of the Trimble lawsuit. And that the defense cost exists regardless of the ultimate liability.
Right, so then their preferably they sought reimbursement for the cost of defense. Do you think that the trial court, implicit in the trial court's order that was an adjudication that your critical was required to defend?
It didn't specifically state that, it didn't specifically rule on it, but in determining an indemnity, that it had to indemnify, it could be presumed.
But one of your arguments is there's a distinction, right? Because there's a distinction because the duty to defend only arises if it is the liability arises from an incident related to the work, not mere presence.
And that's absolutely correct. That was a distinction.
It's not a clear implication, given your own argument, that
Right.
this was an adjudication of the duty to defend as in addition to doing that.
Correct. The court didn't specifically rule on it, so.
So where does that leave us for jurisdiction? I mean, if the public possibility that taken on its face, the order only concerns indemnification. And if we decide that that's that is independent, then we have no jurisdiction.
If that's what you decide, but I do believe that considering that the only reservation was for costs in this particular case, that they can be viewed as independent of each other, and the court could accept jurisdiction in this case.
Council, you're gonna have to wrap it up, please.
Okay, so Your Honor, I believe that the reason that the 2013 amendment was made is because the parties actively decided that there were ambiguities within the two provisions.
Didn't it resolve that though?
Well, I believe they did not.
By acknowledging it, it resolved it. Right?
I believe it did not because for a couple of reasons. One is that we cited case law in our brief that if you have to go to different contracts or different provisions to determine the meaning of a contract, then that contract is unenforceable. And in this particular case, there were different issues that were did not act in harmony with each other. In addition, as I indicated, I do not believe that the waiver of the agency argument, because the court in its order determined that he specifically looked at all of the contract, and the question is for waiver is, did the court have an opportunity to address the issue? And the court in its ruling said that it looked at all the agreements, including the work orders, and the court on its own decided that it was going to delete certain language of the contract and ignore complete amendments to determine the meaning of the contract and to come to the conclusion that the it was going to rely solely on the 2008 agreement, but in that process, the court had to look at different portions of the contract to determine its meaning and had to actively delete phrases and to ignore provisions of the contract. And the case law provides that the court is supposed to try to give meaning to every part of the contract because it's all one. But in this case, you had the different provisions and different amendments in the different work orders. And the court decided it should ignore some of the work orders and some of the amendments. And that is under Florida law, not proper. But in
Counsel,
addition,
you
I'm
used
sorry.
up your time. So
thank you. And Your Honor, we would request critical intervention, would request that the court reverse the trial court ruling because the language of the contract was not clear and was ambiguous.
Thank you both.